Imagine you're taking a drive, just, a picturesque drive right along the Pacific Coast Highway.
It's a beautiful stretch of road.
It really is. It's so beautiful that it's iconic, right?
Hmm?
But it's also so dangerous that the locals literally call it Dead Man's Curve.
Yeah, that contrast is pretty stark.
It is, and we are going to abruptly shatter that scenic image today because we have to talk about the horrific events of October 17th, 2023.
Right. It's an undeniably catastrophic tragedy.
Completely undeniable. Tragically, 4 people were killed. And legally speaking, it's undeniably manslaughter, but the question is it murder?
And that is the ultimate legal friction point we're looking at.
Exactly. Our mission for this deep dive is to explore the incredibly high-stakes legal chessboard surrounding Fraser Bohm. He's a 20-year-old accused of killing 4 Pepperdine University sorority sisters.
Their names were Niamh Rolston, Peyton Stewart, Asha Weir, and Deslyn Williams.
Right. And while the tragedy of losing them is undisputed, this deep dive isn't just about the crash itself. We're dissecting a very specific pretrial motion.
Yeah, a high-profile defense attorney is basically attempting to get the murder charges dropped entirely.
And his argument is that the prosecution withheld crucial evidence. Okay, let's unpack this.
Yeah.
Because, you might think a car crash is a clear-cut case, but you're about to see how one single word, the word murder, changes absolutely everything.
It really does, because when we talk about murder, we usually imagine premeditation, right? Like malice or a weapon.
Exactly. You picture a calculated crime.
Right. We don't typically imagine a 20-year-old in a BMW on a scenic highway. But the law has a very specific, sharp mechanism for dealing with extreme recklessness. And that mechanism is being tested to its absolute limits here. The line between gross vehicular manslaughter and implied malice murder is incredibly thin.
Just razor thin.
Yeah, and today we are going to walk right on that edge.
Before we can really understand the defense's legal maneuvers, though, we have to establish the facts on the ground.
Yeah.
Like what actually happened that October night.
We need to look at the anatomy of the tragedy on the PCH.
Right. Let's start with the victims, because they are the center of this. We are talking about 4 seniors at Pepperdine University.
Sorority sisters.
Yeah, Niamh Rolston was 20, and Peyton, Asha, and Deslyn were 21. These were young women who were they were months away from graduation.
You're starting their lives.
Exactly. And they were simply getting out of a car on the shoulder of the PCH. They were doing something totally normal.
Right. Entirely mundane.
Yeah.
And then on the other side of this, you have the driver, Fraser Bohm.
He was 20 years old at the time.
Yeah, and he was driving a BMW. And the sources note a specific detail here that, it feels relevant to the broader narrative. This high-performance vehicle was actually a gift from his parents for his 16th birthday.
Oh, wow. So you have a really young, relatively inexperienced driver in a very powerful machine.
Exactly.
Which brings us to the physics of the crash. So the speed limit on that specific stretch of the PCH is 45 miles per hour.
Which already requires a lot of attention, on a curvy coastal road.
Right, especially with shoulders where cars might be parked. The Bohm was allegedly traveling at 104 miles per hour.
104. I mean, at that speed, you were traveling roughly 150 feet every single second.
That is just incomprehensible.
It is. By the time your brain even registers a hazard on the side of the road, you've already traveled the length of a football field. The car basically becomes a ballistic missile.
But, the prosecution didn't just guess that speed based on skid marks, did they?
No, not at all. They pulled it straight from the BMW's black box, the event data recorder.
And this is where the whole case pivots. The black box data showed that he accelerated from 93 miles per hour to 104 miles per hour in exactly 2.5 seconds, right before hitting the young women.
And that data is the absolute cornerstone of the prosecution's decision to charge him with 4 counts of murder.
Let's just pause on that. Think about how fast 2.5 seconds is, That's just a deep breath.
Yeah, in and out.
Right. To go from 93 to 104 in that window means his foot was planted to the floor. It wasn't just like drifting over the speed limit. It was an active acceleration.
Exactly. What the prosecution is doing is using that vehicle telemetry to establish a potential mindset of extreme recklessness.
And the sources actually compare these 4 murder charges to the high-profile Brian Koberger case in Idaho, which really emphasizes the severity.
Yeah, they are treating a traffic collision with the exact same legal severity as a targeted stabbing.
Wow. Okay, so that acceleration brings us to the crux of the legal battlefield. Murder versus manslaughter.
Right. Enter the defense attorney, Alan Jackson.
And Jackson is a massive name in criminal defense, right?
Huge. He recently represented Karen Reed. He is known for very aggressive, tactical defense strategies.
So Jackson comes in and files a common law statutory motion to dismiss, along with what they call a renewed 995 motion.
Yes.
And the really wild part is he is not trying to drop the 4 counts of vehicular manslaughter with gross negligence.
No, he is exclusively targeting the 4 counts of murder.
So what does this all mean for the listener? If I understand this right, Jackson is walking into court and basically saying, yes, my client was reckless. Yes, it was dangerous. But it wasn't murder.
That's exactly it.
Is it common for a defense attorney to essentially concede manslaughter just to fight the murder charge?
Well, it's a very calculated risk. What's fascinating here is the purpose of a preliminary hearing in the first place.
Right, because that's where this all went down initially.
Exactly. A preliminary hearing exists to weed out unsupported charges before you even get to a trial. The magistrate, in this case, Judge Ed, has to decide if there is probable cause.
Okay, got it.
Jackson is arguing the legal standard for implied malice murder. He says it requires proof that the natural and probable consequence of an act is nearly certain to cause death.
Nearly certain. That's a huge bar to clear.
It really is. And Jackson claims the prosecution fundamentally compromised that preliminary hearing.
Right, by withholding evidence.
Yes. He says they hid 3 key pieces of evidence that would have negated the probable cause for murder. He says Judge Ed made a decision on an incomplete record, which violates the defense's constitutional rights.
Okay, so let's get into these claims. Withheld evidence claim number 1. This is basically the witness versus the data, right?
Yes. To prove the hearing was compromised, the defense went after the prosecution's star witness using digital forensics.
The witness is a guy named Victor Kandra. And Kandra testified that he was at a red light prior to the crash, and he saw Bohm with his phone down between his legs.
Right. He said he saw Bohm's thumbs moving, like he was actively texting.
And Kandra even claims he interacted with him. He said he told Bohm, hey, you need to be careful. You're going to hurt yourself.
Which is pretty damning testimony if you're trying to prove a conscious disregard for human life.
Oh, definitely. And then Kandra says the light turned green and Bohm just gunned it.
Right. But here comes Jackson with the digital rebuttal. Jackson claims his forensic expert analyzed Bohm's phone later and found something huge.
The locked window.
Exactly. The data showed the phone was completely locked from 8:15.59 p.m. to 8:03.06 p.m.
That's a solid 15 minutes of no user interaction right before the crash.
Yep. So Jackson uses this to accuse Kandra of lying under oath, and he accuses the prosecution of hiding the proof.
But the prosecution has a defense for this, right? They didn't just sit there and take it.
No, they explained the timeline of the digital forensics. They said at the time of the preliminary hearing, they only had a partial download of the phone.
Because it was encrypted.
Right. They didn't have his passcode. They disclosed everything they had at that moment. In fact, the defense actually used that partial data to cross-examine Kandra at the hearing.
Here's where it gets really interesting. It's like the prosecution handed over a locked diary, and the defense is mad they didn't get the key until later.
That's a great way to put it.
But didn't the defense already stipulate to the fact that there were no texts based on the early data anyway?
Yes, they did. And that is a brilliant tactical response by the prosecution. They point out that they were perfectly willing to stipulate, officially on the record, that no texts or calls went through.
Because the early telemetry showed that much.
Right. So the prosecution is arguing that getting the full unlock code later doesn't suddenly turn Kandra into a malicious liar.
Wait, how was he not lying if the phone was locked?
It comes down to how human memory works. Witness testimony can easily conflict with digital data without it being perjury.
Like Kandra just misremembered what he saw.
Exactly. Kandra is at a red light. He sees a kid in a nice car, maybe looking down, maybe his hands are fidgeting. Kandra's brain fills in the blank and says, oh, he's texting.
Oh, wow. So he might genuinely believe that's what he saw.
Yes, and the prosecution argues that even if Kandra was mistaken about the phone, it doesn't destroy their entire case. The extreme speed and acceleration still happen.
Okay, that makes sense. So that's the inside of the car. Let's move to withheld evidence claim number 2. This is where we look at the outside environment, the statistics of dead man's curve.
Right. Jackson's team went on a massive statistical dive. They pulled data from SWITRS, which is the statewide integrated traffic record system, plus Caltrans, sheriff's reports, and a specific Stantec safety study.
They really did their homework.
They did, and they focused on that specific 0.8-mile stretch of PCH between Carbon Canyon Road and Las Flores Canyon.
The same exact stretch where the girls were killed.
Yes, and the numbers they found are staggering. Over a 10-year period, there were 179 collisions on this tiny stretch of road.
179, that's insane.
It's 129 from Switters and another 50 from Caltrans. It's a decade of chronic high-speed crashing.
But Jackson uses these numbers in a really unexpected way. He points out that out of those 179 collisions, only one was fatal.
This exact case.
Right. So Jackson argues this mathematically proves that excessive speed on this stretch is not nearly certain to cause death.
Exactly. He is directly attacking the legal definition of implied malice murder.
Wait, so the defense is essentially saying, look at all these people who crashed here and didn't die. Therefore, my client couldn't have known it was deadly.
Yes, that is literally his argument.
Isn't that a massive leap in logic? It's like saying, well, nobody else died playing Russian roulette, so the gun must be safe.
It is a controversial use of statistics for sure. If we connect this to the bigger picture, we are talking about the objective element of implied malice.
Okay, break that down for me.
Implied malice requires an objective reality that the act is highly dangerous. Jackson is saying the math proves it isn't a death sentence. But the prosecution's rebuttal is fierce. They argue that Jackson is relying on a foundation that speed alone is their theory of murder.
Which they are saying is just not true.
Exactly. The prosecution insists their case is about way more than just the speed limit.
Right, because it's the speed combined with that 2.5-second aggressive acceleration.
Yes, and crucially, the context of the pedestrians. The victims were clearly visible getting out of a car on the shoulder. You can't just look at 178 other crashes and compare them, because those other drivers probably weren't doing 104 miles per hour while actively accelerating toward people.
Yeah, that context changes everything. Okay, so that brings us to the third and final claim of withheld evidence. We've looked at the road, we've looked at the phone. Now we have to look inside Fraser Bohm's mind.
The speed kills interrogation. This is about his subjective knowledge of danger.
Right, because initially, Bohm told investigators the crash was an accident. He said he swerved to avoid a car next to him that had hit his driver's side mirror.
But the prosecution notes they actually tracked down that specific car and it had zero damage. The swerving story just didn't hold up.
So then the deputies are interviewing him, and they ask him a very pointed question. They ask if he's familiar with the phrase, speed kills.
It's a classic investigative tactic to probe his state of mind.
And Bohm just voluntarily offers up this tragic story. He says he knows speeding can be deadly because his own friends had died in a car crash.
And for the prosecution, that is a goldmine. They used it to prove Bohm had subjective knowledge of the extreme danger of his actions. He knew personally that speed could kill, and he chose to go 104 anyway.
But Alan Jackson finds a massive complication. He reveals that the prosecution had a Ventura County Sheriff's Police report about that exact crash involving Bohm's friends.
And what did that report say?
It showed the primary cause of his friend's fatal crash wasn't actually just speed, it was a DUI. The driver had a 0.16 blood alcohol content.
Wow, that's a huge detail.
Right. And Jackson argues this completely changes the context of Bohm's knowledge. He accuses the prosecution of withholding this report to maintain their speed alone narrative.
But the prosecution's rebuttal here is actually beautiful from a legal standpoint.
Really? How do they spin that?
They countered that the actual objective facts of his friend's crash don't matter as much as Bohm's personal understanding of them.
Okay, I need to wrap my head around this. Let me try an analogy. It's like if I tell you I'm terrified of swimming because my friend drowned.
Okay, go on.
But it turns out, later, we find out my friend actually had a heart attack in the water. My fear and my internal belief about the danger of the water is still totally real to me, even if my facts were slightly off. Is that what the prosecution is arguing?
Yes, that is a perfect analogy. You are highlighting the exact difference between objective truth, like the 0.1 BAC, and subjective intent, which is what Bohm internalized.
So because Bohm thought speed caused it, his subjective knowledge of the danger of speed is established.
Exactly. The prosecutor points out that Bohm himself stated he didn't know the full story of his friend's crash. But his takeaway, the lesson he learned from that tragedy, was that speed was a factor.
Wow. So adding the DUI fact post facto doesn't change his mindset at the time he snipped on the gas.
Precisely. His subjective knowledge that speeding represents a danger to human life remains completely intact.
Okay, so we have these three massive defense arguments. The locked phone, the crash statistics, and the DUI report. And we have 3 really sharp prosecution rebuttals. How did Judge Ed rule on this?
The judge handed down his decision, and the motion to dismiss the murder charges was respectfully denied.
Denied, so the murder charges stick.
Yes, all 4 of them.
How did the judge justify that with all this new evidence Jackson brought in?
Well, the judge broke his reasoning into 3 parts. First, he looked at the legal standard. He stated that the non-disclosed evidence doesn't actually foreclose the possibility of a high probability of death.
Really?
Yeah, in fact, the judge noted the evidence might even support a finding that his acts were dangerous to human life.
Because 179 crashes prove the road is incredibly dangerous to speed on.
Exactly, it backfired a bit. Then, for part 2, the judge addressed the constitutional obligation.
The Brady violation stuff.
Right. The judge ruled the prosecution actually had no constitutional obligation to disclose the specific evidence at the preliminary hearing stage anyway.
Wow. But what if they did?
That leads to part 3, the what-if scenario. The judge ruled that even assuming arguendo, as they say in law, that the evidence should have been disclosed, it wouldn't have mattered.
Wait, putting all that on the magistrate's desk wouldn't have changed anything?
No, the judge said adding all of it would not have changed the ultimate determination of probable cause.
So, despite all of Alan Jackson's data and phone forensics, the judge basically said, even if I look at all your new homework, the grade remains the same.
That's a great summary.
Why is the bar for probable cause so different from the bar for a guilty verdict?
This raises an important question about how our system works. The threshold of probable cause is very low compared to beyond a reasonable doubt.
Okay.
The judge isn't saying Bohm is definitively guilty of murder. He's just saying there is enough legitimate smoke here to let a jury look for the fire. It's up to a jury to weigh the conflicting evidence, not a judge at a preliminary hearing.
I see. So what happens now?
The result is that Fraser Bohm will face trial on September 5th.
For all 4 counts of murder and all 4 counts of vehicular manslaughter.
Yes. It's going to be a very intense trial.
It's just an incredible tension, isn't it? Between the sheer horrific tragedy of losing these 4 bright young women and this intense microscopic legal battle over the exact definition of implied malice murder.
It really is. It shows how clinical the law has to be, even in the face of profound emotional devastation.
Yeah, it really does. And I want to leave you, the listener, with a thought to mull over as we wait for this September trial.
It's a fascinating case to follow.
It is. Think about how technology is shifting the burden of proof. In an age where your car records your exact acceleration down to the millisecond and your phone locks away your exact timeline, the truth of an accident is no longer just about skid marks on a highway.
Right, it's about data points in a server.
Exactly. As we watch this unfold, ask yourself, when our machines record our every single move, does the legal line between a tragic accident and a murderous intent get clearer, or does it just get infinitely more complicated?
That is the big question.
It really does. Thank you for joining us for this deep dive. You are now thoroughly equipped to follow the intricate legal dynamics of this incredibly tragic case.